Modern Real Estate Practice, page 218. Unit 3, Legal Considerations. Figure 9.2. A sample excerpt from a property disclosure form. It shows D, appliances, heating, plumbing, electrical, and other mechanical systems. This section refers only to the working condition of the following items. Answers all to apply to all such items unless otherwise noted in comments below. Personal property is included in the sale only if specifically referenced in the purchase agreement. Cross out only those items not physically located on the property. It shows like air conditioning, ceiling fans, drain systems, garage door opener, solar collectors, intercom, incinerator, trash compactor to wood burning stove. And you have a questionnaire. Is it in working order? Yes or no? The law requires the seller or landlord of a dwelling built before 1978 to do all of the following. Disclose the location of any known lead-based paint in the home, in both the dwelling unit and the common areas if applicable. Provide a copy of any report concerning lead-based paint in the home if it has been inspected. Give buyers or tenants a copy of a pamphlet on lead-based paint prepared by the U.S. Environmental Protection Agency. In addition, buyers, but not tenants, must be offered at least a 10-day period in which to have the home tested for lead-based paint. Specific warnings must be included in the purchase agreement or lease, along with signed statements from the parties acknowledging that the requirements of this page 219 law have been fulfilled. The signed acknowledgments by buyers, sellers, and their agents must be kept for at least 3 years as proof of compliance. The law also imposes responsibilities on real estate agents in transactions involving pre-1978 housing. An agent is required to ensure that sellers or landlords know their obligations under the disclosure law and fulfill those obligations. It is also the agent's responsibility to make sure that the purchase agreement or lease contains the required warnings, disclosures, and signatures. Sellers, landlords, or real estate agents who fail to fulfill their obligations under this law may be ordered to pay the buyer or the tenant treble damages, 3 times the amount of actual damages suffered by the buyer or tenant. Civil and criminal penalties may also be imposed, although a real estate agent may be held liable for a seller or landlord's failure to comply with the law. The agent isn't responsible for information withheld by the seller or landlord. Comprehensive Environmental Response Compensation and Liability Act. CERCLA is the acronym. CERCLA. CERCLA is a federal law enacted in 1980 and reauthorized by the Superfund Amendments and Reauthorization Act of 1986. The acronym for that is SARA, S-A-R-A, which imposes on owners, lenders, occupants, and operators liability for correcting environmental problems discovered on a property. The statutes are often collectively referred to as Superfund laws because they established a fund to clean hazardous waste sites and respond to spills and releases on property. A landlord is liable under CERCLA when a release of a hazardous substance has occurred on the property, regardless of whether the contamination is the result of the landlord's actions or those of others. The owner can be held responsible for the cleanup. Under the concept of innocent landowner immunity, however, the landowner who did not actually cause the contamination can seek recovery reimbursement for the cleanup cost from previous landowners or the Superfund. Appraiser's perspective. As stated early on in this textbook, the most common form used to report a residential appraisal is the 1004 URAR. In this form is the statement of assumptions and limiting conditions. Number 5 of the statement of assumptions and limiting conditions states the following. 5. The appraiser has noted in this appraisal report any adverse conditions such as needed repairs, deterioration, the presence of hazardous wastes, toxic substances, etc., observed during the inspection of the subject property, or that he or she became aware of during the research involved in performing this appraisal, unless otherwise stated in this appraisal report. The appraiser has no knowledge of any hidden or unapparent physical deficiencies or adverse conditions of the property, such as, but not limited to, needed repairs, deterioration, the presence of hazardous waste, toxic substances, adverse environmental conditions, etc., that would make the property less valuable, and has assumed that there are no such conditions and makes no guarantees or warranties express or implied. The appraiser will not be. Extra little note, there was, remember, Comprehensive Environmental Response Compensation and Liability Act, CERCLA.